Mr. Fritter, look at me. You so much. Can you imagine? So if I go like this, is that threatening or harassing? It most certainly. That you've done it, the date, time, location of where you've done it, so that I can verify that you've done it. And if you don't do it, you will stay with me.
Enter the shoulder and then jerk back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code.
He wasn't
This
just
law can't be like that.
It wasn't just announced. He went half.
So you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28, 2024, the officer came to a stop behind the defendant's vehicle, and the light turned green, and the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage, and standard sobriety tests were administered. HGN 6 out of 6, the walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's eligible, Your Honor.
All right. How many prior DWIs does he have?
He has one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart, and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel, and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're going to have you wait for him now, but after today, I'm going to waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right. I'm going to have you sign a reset. I'll have you meet with Fleischer for bond conditions, and we'll just have you waiting back for Mr. Stewart to show up. Okay? Please.
Right this way.
Ready?
Yes.
Come on in.
Good morning, Your Honor.
Hey, how are you? Mr. Stewart, what's new?
Sir, how was your New Year?
Great. We did PC on your case.
Okay.
We just did stand up. What's your guy's name again?
My last name is Allen, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So refresh my memory. What happened?
So in Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The defendant,
But he had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there were other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there were other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here, elucidated, is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of, the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information, and I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps he's, well, I mean, I don't want to speculate, and you're saying, well, maybe he did it because of this, but I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know. I mean,
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
right, but you got to articulate facts as well, right? So according to the statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we look at the statute for failing to maintain a single lane, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
It's 545.460, isn't that it?
Fleming, yes, Fleming, Hardin.
545.060, Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely. Or that there was
Judge,
anything
I
unsafe
also
about it.
have the list of, where under Texas law where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic, to decelerate.
Let's do this. I mean, this is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go?
Oh, yeah.
Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time.
Yes, sir.
Right? And give you time to take a look more so if you need to, you too as well, if you want to try to find a case law. Let me just go through because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure.
Just gonna get with the sheriff's and prosecutor and have a discussion.
Craig.
Good morning again.
Hey.
I wanted to reapproach regarding the PC on Mr. Allen's case. I know the state has emailed me some cases that they wanted to cite to.
Morgan.
Judge.
I don't know whether someone else wanted to speak to that.
Yeah. If we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failing to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
No, but one of the things is there's an element of unsafetyness, right?
And Your Honor, there are other vehicles around. As the officer articulated in the dims, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the dims.
But I get it. But where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
And furthermore, Your Honor, he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder, and there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerk back, it implies that there was not one of those 7 reasons to allow another car to pass, to stop or park, or to accelerate before entering the main lane of traffic or decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute on the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that taking that into account with Hardin, which he veered out of, he failed to maintain a single lane with other vehicles around, provided enough of a community danger to allow the officer to perform that initial stop.
Man,
Where's the danger?
It would be the other vehicles present, Your Honor.
He doesn't articulate that, though.
He does articulate that there are other vehicles.
All he says is there are other vehicles.
And Judge, that is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles within the vicinity for it to be a danger.
Right. In the case law,
You don't know if it's in the vicinity, though. All he says is that there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles. And that's so vague and conclusory.
Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough for there's other vehicles around to provide that additional threshold for failing to make a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate
Right.
there is a permissible reason.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that this defendant violated, which is veering onto the shoulder, he did not do so for one of the 7 permissible reasons, and thus the officer has reasonable suspicion to stop him.
You're veering. That is 545.060, right? Isn't that part of that's the weaving, right?
It's a different one.
Because you just said there's another violation of the transportation code.
Yeah, and it's under 545.058 is for entering the shoulder.
may I address the court, please, Your Honor?
Hold on, let me pull that code up. So that's 545.058.
The transportation code.
All right, let's see. That is driving on an improved shoulder. An operator may drive on an improved shoulder to the right of the main traveled portion of a roadway if that operation is necessary and may be done safely, but only if to stop, stand, or park, to accelerate before entering a main travel lane of traffic, to decelerate before making a right turn, to avoid a collision as permitted by an official traffic device. Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense. That's their case. It says the exact, that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop Applee for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, I would like to, highlight these two cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the Fourth Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is there an element of unsafeness? That's all I want to know.
To just address one point briefly, in the case Lothrop, they do say that really on an improved shoulder is not prima facie case evidence of an offense. However, if it states explicitly that the offense of illegally driving on an improved shoulder can be proved in one of two ways, either driving on an improved shoulder was not necessary part of achieving one of the 7 approved purposes which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to the 7 articulated purposes in the statute that are not present here. He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code.
He wasn't
This
just
law can't be like
It
that.
wasn't just announced, he went halfway in. So he veered halfway into the shoulder. It wasn't just like a little deviation. He said, the officer said halfway into the shoulder and then jerked back into the lane. So he went out and then came back into
So
the
are
lane.
we supposing that that's like half a second of driving on an improved shoulder? Is it 1 second? Is it a minute? Is it?
I'm sure it should matter. I mean,
Because the legislature articulated 7 specific reasons why that would be permissible, and they wouldn't have.
If an old grandmother who is 70 years old is driving on a freeway and accidentally,
And but that would provide the minimal justification just to perform an investigatory, a stop, just to investigate. It wouldn't be an arrest or anything like that. It would just be the traffic stop would be allowed at that point.
I don't know. I don't think that the officer wrote enough in the report. I don't think that the unsafetyness as far as, saying that there are other cars around. I just don't think that there's enough.
Yes,
All right,
Judge.
I'll find no probable cause.
Thank you.
Okay. Fritter. On bond?
Yes, sir.
Oh, I see.
Okay.
Mr. Fritter, come up. Mr. Fritter, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, please.
September 19, 2024, an officer conducted a follow-up in regards to an assault on a family case. Upon further investigation, the officer made contact with the complaining witness who reported that the defendant had been harassing her since September 18, 2024 by sending her videos, voicemails, and text messages containing horrible remarks, approximately 50 to 60 messages in total. In the voicemails, the defendant curses at her, asking, "Where are you? Why the fuck aren't you at work?" and calling her various names. Additionally, the complainant showed the officer text messages of the defendant telling the complaining witness, "Kill yourself and I want to watch you suffocate, and your family hates you." The complaining witness indicated that the continual harassment is making her fear him even more. Complaining witness was able to give officers the defendant's identifying information and positively identify the defendant as a person who has been harassing her.
I see that he has also picked up a felony assault against this complaining witness as well.
Yes, sir.
Okay, what happened in that one? And I'm assuming it's the same date as this one, so I'm assuming it's out of the same transaction?
I'm not sure. So it says that I don't believe so. It says that on September 18th in Harris County, officers were dispatched to an assault. The complaining witness advised that the defendant came home upset about socks not being in the closet. The defendant punched the complaining witness with a closed fist on her foot twice, on her right thigh and twice on her left thigh, causing pain. The complaining witness advised that the defendant grabbed her by the arm and forcibly shoved her out of the house, throwing her on the porch. She advised that she felt pain, and she advised that this has been an ongoing issue for the past 2 years. The officers observed purple and green bruises on her arm, foot, and her legs. The bruises were green, purple, and red and of significant size.
Is there a no contact order in this case?
Judge, who's the defendant?
This is Mr. Fritter. He hasn't harassed, Mr. Fritter, let me tell you something now. You scare me. And you scare me something good. You have since 14 assault, trespass, deadly conduct, assault, DWI, forgery, and now a harassment and a felony assault.
Judge, there has been a note filed, but there is no protective order in this case.
Is there no contact in the felony case whatsoever?
I'm checking the bond conditions. It's no threatening or harassing at this time. Would ask if that be a no contact in this court, Judge.
I don't see that the rip has been.
Are you Miss Lisco?
Yes, sir.
That's Miss Lisco right there. Come up, ma'am. Come up. I'm sending you for a drug and alcohol test right now, Mr. Fretter. I want to protect you as much as I can. No one has to have this kind of treatment whatsoever for any reason. And I will do everything in my power to protect you. All I need you to do is tell me. All I need is please give me the word. Mr. Fritter, look at me. You so much. Can you imagine what life is like when someone has to walk on eggshells because they have the fear that if they make someone mad in the smallest respect of having socks not in the damn drawer, they're liable to get a beating? Can you imagine what life is like to live with that kind of fear? You're going to live it with me now, because one false move, I'm going to make your bond so high your head will spontaneously combust. But no one, and I mean no one, should have to live with that kind of fear. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. And I don't know if I'm going to allow you to have contact with Miss Lisk. But if I find that you treat anyone or put anyone in fear or put anyone in harm's way, so help me, I will grow horn and tails because I will be so upset, and it will be on you. Do you understand?
Yes.
Abel,
Yes.
I'm going to keep Mr. Fretter so close to me that it's just ridiculous.
Yes, sir.
I'm entering what's called a magistrate's order for emergency protection. This is a court order that identifies her as a protected individual. You're not to have any kind of communication whatsoever. You're not supposed to have any, you will not have any threatening or harassing contact. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it's enough for me to put you in jail and make your bond $150,000, maybe 50, maybe 20. But I will do, Mr. Fretter, I will do everything in my power to protect every single person of this county. And I don't care if you're kicking, screaming, crying because you go to jail and don't have anyone to bond you out.
Your husband and wife of 10 years is kind of difficult situation together.
I want to protect you, ma'am. And you know, the problem is that now that he's picked up these two cases, times will be just even more stressful. We have these protective orders. They're basically like cooling off motions so that, you know, you can separate, enough time will pass. People can kind of cool down, you know, so they're not under the stress of the excitement and then unleash on you. The last thing I want is for you to suffer any kind of harm whatsoever, you know, and I that's all I want, you know. All I'm asking is how things should be normal. Like, I'm not asking him for him to do Pythagorean's theorem here. So I don't know. You know, what I'd like is if you please just talk to our DAs here. But I'd like you to have their phone number at the minimum so that should anything ever whatsoever, all you have to do is let us know. And then
I haven't been in contact with the DA, so should it be assault?
I'm here for you. And I want to make sure that you're okay. You know, I've given him a lawyer. He knows what's expected of him. And I'm going to drug test him like crazy to make sure that he's not using alcohol or dope. In fact, I mean, I'm going to test him 2 times a week. I mean, I'm setting him now because I want to know what, if anything, is in his system. And then we'll go from there.
Judge, he will come back to positive, but that's prior use from
What? What were you going to test positive for, Mr. Freder?
Marijuana.
Okay.
And ketamine, and probably some other stuff that could have been in the ketamine. But I mean, straight up, that's probably it.
Mr. Freder, I'm going to test you. These are your bond conditions that are going to apply to you now. And if you fail to live up to these bond conditions, I'm just going to let you know. That's it. You will appear to me here 2 times a week to take drug tests. And if I find anything is in your system, and I don't care what it is, I'm going to lock you up. You're ordered not to use any kind of dope or alcohol. And if you can't get this monkey off your back, because I am now giving you the opportunity to do it on your own. If you're incapable of doing it on your own, then I'm going to do it for you. Do you understand? No dope, no alcohol. And when I mean no alcohol, I mean no alcohol from any source. No isopropyl alcohol, cakes, candies, foods, gums, energy drinks, tequila, lollipops, hair dye. I've heard it all, and I don't care. You come to me test positive, you'll stay with me. I also want you 3 times a week to do anger management classes so that we can deal with the anger issues. Look at me. 3 times a week. And I want a piece of paper showing me that you've done it, the date, time, location of where you've done it, so that I can verify that you've done it. And if you don't do it, you will stay with me. You now have the opportunity to address these things on your own. If you don't, you will be doing it with me. And if I get one, and I mean one breath that she's been mistreated in any way, shape, or fashion, holy freaking moly, okay? Right now. And then, ma'am, if you'd be so kind, please, I'll have you speak to them here momentarily. Rachel, this is my card. If you ever need anything, all you have to do is get in contact with me. And I'm here for you. Whatever you need, anytime, day or night. I don't care. You, really. Okay.